Just gonna give it like one more minute to let everybody kind of come in, and then I will start. All right, I'm going to go ahead and get started. Hello, everybody. Thank you so much for joining us today. In case you're not sure who I am, my name is Elise Fry. I'm the Director of the Healthcare Operations here at URL Insurance Group. Feel free to reach out to myself or anyone on my team for any under 65 and group health assistance. Some quick housekeeping items. There's a chat feature, a Q&A feature. Feel free to ask any questions. There are some handouts, including the sign-in sheet for the CE course. So now that we have that out of the way, I'm excited to have Rocco back. He's been our all-star CE credit webinar guy. And we're going to go over FMLA with everybody. And today is a 2-hour CE course for PA health and life insurances or licenses only. So I hope you find it valuable. And without further ado, thanks again for coming, and take it away, Rocco.
Thank you, Elise. Appreciate it. Well, good afternoon again, everybody. My name is Rocco. I'm with Mutual of Omaha. I partner with Elise and the URL team, as well as other brokers in the central and northeastern Pennsylvania. I see somebody mentioned in the chat, what's the static? Just to confirm, are you still hearing static when I'm speaking by chance, or is it okay? Elise, are you hearing static?
So not really. It's a little wonky, but it's not kicking back like it was for me. Let me try to get a hold of IT real quick.
Okay, I just changed my microphone. Does this sound better? Are we still hearing static?
So much better.
Much better? Okay.
It shouldn't, hold on. You just changed. Okay, it's better now. Everybody's confirming it's better now.
Excellent. Thank you so much for confirming. Appreciate it. Okay, good. Sorry about that. So I partner with Elise, the URL team, as well as other brokers in the central and northeastern Pennsylvania market for ancillary benefits. So group life, short-term and long-term disability, dental, vision, accident, critical illness, and hospital indemnity, as well as absence management, which is specific to FMLA ABA leave for group employers with 50 or more employees, which is primarily what we're going to be speaking about today in this course. So like Elise mentioned, it is a 2-hour, 2-credit course. Just to give you a heads up, I don't anticipate this lasting the full 2 hours, but there is that sign-in sheet located in the handout section of this presentation. Please make sure to fill out that sign-in sheet. That is what's submitted to the state to provide you with your CE credits. And even if it doesn't take the full hours, please make sure to still put 11 a.m. start time and 1 p.m. end time on that sheet before you submit it to Elise. So FMLA and compulsory leave. Now, some of you might be very familiar with FMLA and have had conversations with clients or prospects about a third-party absence management solution to help manage their FMLA and other leaves. Some of you might not have. But what we found with our broker partners is that being able to have the conversation about a absence management solution for HR managers really gets their ears to perk up. There's, as you'll find throughout this presentation, a lot of ins and outs, compliance information that HR managers are tasked with managing specific to FMLA and other leaves depending on their state that can be really burdensome, especially with all of the other things that they have.
Rocco, there you are.
Uh-oh. What happened?
You like went away for a second. You're back now. I don't know. The wind must be blowing again. You know how that goes.
Oof. Okay. Well, feel free to interrupt. Let me know if I cut out again.
Will do.
Hopefully it's better from here on out. Sorry about that, folks. So what I was saying was what we found is that with our broker partners is that being able to have the conversation around FMLA absence management solutions to help take that off of an HR manager's plate can be extremely beneficial because there is a lot to manage just specific to FMLA and whatever state leaves apply to the state the employer is in, on top of everything else that they're managing, payroll, benefits, the list goes on. So being able to offer a potential absence management solution to prospects that you're speaking with or clients can be a real game changer and advantage. And we'll talk through a lot of that information throughout this presentation. But in any event, it's a good course. It's something that is really beneficial to have some arrows in your quiver to be able to discuss with clients and prospects and be able to talk about a solution for them. So throughout this presentation, we'll go through a ghost story or an example situation, the basics of FMLA, the employer and employee responsibilities, some state level leave law information, as well as the most common employer challenges that employers and HR managers have with managing these leaves. Elise, I saw you popped on for a second. Are we all good?
It was my stuff. My portion was frozen, so I removed myself and came back. So I just, here I am.
Okay, excellent. Okay, so just want to preface by saying I am not a fan of reading directly off of slides, but that will have to happen sometimes throughout this presentation just because of the nature of how it's set up. For example, with this slide running through a story, and a lot of the slides just have facts on them, which will require me to read off the slide. So for an example, I'll run through this story. So one employer's nightmare. A long-term and well-regarded maintenance worker for a large hospital system found himself dealing with not one, but two sick and elderly parents. He started using his vacation and personal time to help care and transport one parent who was receiving chemotherapy for cancer, while also spending support time with another who was stricken with Alzheimer's disease and in an assisted living facility. During this time that the employee was taking off from work, the maintenance department instituted a new performance measurement that tracked the tasks completed monthly by employees, thus charging him with low scores in his job, even though it was due to his time off for caring for his parents. Eventually, his employment was terminated for the poor performance. The worker sought legal counsel and sued the hospital system for violating his rights under the Family Medical Leave Act, which is what FMLA stands for, and for associated pain and suffering for being fired from a job that he had held for years. This is not uncommon. It is quite common for employees to bring an employer to legal action due to FMLA noncompliance. So in the end, the hospital system and janitorial staff supervisors were found liable, and the worker was awarded $11,650,000. Of that, $900,000 of the award was against the two individual supervisors of the hospital, each owing $450,000 to the plaintiff. We're not talking about peanuts here. This is a federally regulated law that does have major compliance responsibility and very large repercussions for being non-compliant. So that's just to paint the picture of the types of situations that we're speaking about with these leaves and the impact that it can have on employees and employers. So why FMLA leave management is so important? Well, the cost of non-compliance is twofold. So on one side of the coin, there is the liability of the employer for not being compliant and not approving a leave that should be approved, or even approving a leave that should not be approved, and the potential impacts that that might have. For example, like we just saw in that story, terminating an employee due to poor performance during a time when they were caring for family members, which is covered under FMLA. And there's also the productivity side of the coin, where if an employer is just green stamping and approving any request that comes their way for FMLA out of typically fear for being non-compliant and denying something that should be approved, they often end up approving a lot of claims for FMLA that should not be approved, which then results in employees taking advantage of that, taking time off work when it's really not needed, and having their jobs be protected, which is getting hands off of the deck for the employer that are much needed to help keep the organization running, which can cost the employer a lot of money. The Department of Labor has increased compliance audits. They do keep an eye on this, and they keep a very close eye on it. And as many as 70% of eligible employers may not be in compliance with the law. Complexity is also growing with state leaves, as we'll see towards the end of the presentation about state leaves. They are ever changing. Not only the states that already have state leaves in place that are continually changing and adjusting them each year, but there's also more and more states each year that are adding state leaves. So keeping track of all of that, especially for employers that have employees in multiple different states, can be a lot to manage. Also, feel free at any point throughout the presentation to put a question in the chat. You do not have to hold questions until the end. So a little background about FMLA. It was enacted in 1993 to offer job protection and job equality between men and women. It is an entitlement, not a benefit. 65% or more of FMLA leaves are caused by the employee's own medical condition. A lot of employers usually might think that FMLA is only regarding one's own medical condition. But as we saw earlier, FMLA stands for Family Medical Leave Act. So the medical part is specific to the own employee, but that family piece involves care for other family members as well. So it does not just have to be due to their own medical condition. It can be related to something for a family member. The number of states with their own leaves is increasing on an annual basis. While a separate law, Americans with Disability Act, as a lot of us know as ADA, often affects the same employees as FMLA and offers added risk to the employer for non-compliance. Enforcement and complexity of the law continues to evolve, further putting employers in jeopardy of non-compliance. All right, so employers that are eligible for FMLA will have to have at least 50 or more employees within a 75-mile radius. Now, that does not mean that groups with less than 50 employees in a 75-mile radius cannot abide by FMLA laws, but they are not required to. This is regarding both private and public employers. And as far as employee eligibility, they must have completed at least 12 months of employment and have worked for the employer for at least 1,250 hours during the year prior to the leave that is requested. And those 1,250 hours exclude vacation and sick days, holidays, and other leaves. So that is active work. There's one provision in FMLA that's important for employers to be aware of, which is the break in service rule, which does exclude military service. So for example, if an employee works for an employer from 2008 to 2011, they've obviously satisfied that 12-month work requirement and they're eligible for FMLA. In 2015, the employee is rehired, so they left work in 2011, they returned to work at that employer in 2015, which is 4 years later, and then within 6 months, they apply for FMLA leave. The employer might think, oh, well, they haven't returned to work for 12 months, so they're not eligible. But because that employee had returned to work within a 7-year period, they are still eligible and they maintain that FMLA even though they hadn't returned to work for a full 12 months yet. And this, again, is excluding military leave. So if the employee had been in the military for over 7 years and then returns to work, they would still be eligible. So what does FMLA provide? It is a non-paid job protection, again, that is federally governed. So it provides up to 12 weeks of unpaid leave during a 12-month period, or 26 weeks specific to military leave. The employee must be returned to the same or equivalent position after returning from their leave. So during the 12 weeks that they're out on FMLA, that protects their job and does not allow the employer to terminate that employee. And once they return to work at that employer, the employer is held responsible to allow them to return to either the same or an equivalent position. And also, their health benefits must remain intact during that FMLA leave as well. And once the employee returns, those health benefits must remain the same or equal as they were prior to their leave. So their job, their pay, their benefits, and any terms and conditions of their employment must be the same or equal or similar or equal to what it was prior to their leave. After the full 12 weeks of FMLA is satisfied and the employee does not return to work, the employer is not obligated to maintain that employee any longer, and they will have the option to then terminate that employee. Just reading the chat quick, somebody mentioned that they were on their phone in the beginning, they switched to their laptop. That should be okay. Somebody else asked if the slides are available. Sure. After the presentation, I can provide them in a PDF format. I will send that to you, Elise, if that's okay.
Yep, you can send it to me, and then I will do a mass email with it to everybody.
Excellent, that sounds good. And just to check in too, how are we doing with bandwidth? Coming through okay? Smooth?
It seems to be coming through okay on my end. I had to close out all my stuff. My system is being wonky, but it has nothing to do with you.
Okay, just wanted to make sure. Okay, so there's another provision in FMLA called the key employee provision, which states that key employees, which are defined as the top 10% of wage earners within the organization, can be excluded if their absence is deemed by the employer to cause grievous economic injury. So while an employee is out on FMLA leave, they are eligible to maintain any benefits that they had in place with the employer during that FMLA leave. So most health policies will include continuation of coverage while on approved FMLA leave. And as far as the ancillary benefits that Mutual of Omaha provides and other group insurance carriers, life, disability, dental, vision, etc., are required by law to include continuation due to FMLA. And that also does apply to disability, both short and long-term disability. Some of you might be aware it's really not all that common for disability plans to include any type of continuation while an employee is not actively at work, but they do have the ability to continue short and long-term disability for FMLA specific leaves for up to that 12-week period. Employers can either continue to pay whatever premium is owed for that coverage that is continued, or they can have the employee continue to maintain to pay those premiums while they're out on leave. Employees will have up to 30 days to make up a delinquent payment while on FMLA, and the employer can recover payment from the employee if they had funded it, the premiums for them, and the employee does not end up returning to work after their leave is over. So how does an employee qualify for FMLA? So like we discussed earlier, there's the family portion and the medical portion of FMLA. So the medical piece is due to an employee's own serious health condition, and the family piece is due to the employee needing to take time off of work to help care for a family member with a serious health condition, which includes parent, spouse, or child, or due to the birth or adoption of a new child that would be covered under FMLA, or military leave, so caregiver leave or qualified exigency. I do see a question in the chat. So when an employee has exhausted their FMLA but is still unable to return to work, do you recommend placing them on COBRA or maintain their group health coverage, but just require them, to pay the full premium? Is there a best practice? So it seems this question is more specific to group health coverage, which unfortunately I am not extremely well versed in. I just work in the ancillary space. But to the best of my knowledge, that will depend on the carrier in force and the policy in force and the way that it's written, which would determine how and which options employees would have to continue their coverage outside of FMLA.
I can typically answer that. So once they've exhausted the FMLA and if they're still unable to work the allotted amount of hours required to be offered health insurance, they would be offered COBRA. And it's up, depending on the size, well, it's going to be large group. So it's going to be federal COBRA, and it's up to 102% of the premium, but that's up to the employer. They can charge them, if they don't go through a TPA and they're administering it themselves, they can charge them nothing, 100%, 102%, but nothing higher than that. So that's up to them. But that would be the proper way to do it. Once this is exhausted, they move into the next kind of phase, which would be the actual COBRA portion.
Thank you, Elise.
You're welcome.
All right. So if an employee is out on FMLA due to their own medical condition, serious health condition, how is that actually defined? Well, it's due to hospitalization, inpatient care, or absence of 3 or more days from work and treatment 2 or more times. It can be due to pregnancy, a chronic illness, a long-term condition, or due to having multiple treatments for a condition, when failure to have such treatments would likely result in an incapacity of more than 3 days or surgery. So I see a question in the chat. Can a foster parent operating under child welfare qualify? So it might be on the next slide or maybe in a couple slides here. We will define what a family member would qualify as, and that will include information on that for you. So what is a serious health condition? This is continued. Could also mean 2 visits to a healthcare provider within 30 days of incapacity, but the first visit must be within the first 7 days. A condition that renders a person incapacitated for 3 consecutive full calendar days, or chronic health conditions, at least 2 visits a year to a healthcare provider. There are many conditions that fall into the gray area, and additional consideration must be paid to determine whether they fall under FMLA's definition of a serious health condition. So just to hammer home again, this is one example of how burdensome FMLA leave and managing this for employees can be for an HR manager or whoever's managing it at the company to try and determine whether or not this individual's leave request should actually qualify under FMLA. And they're tasked with having to make that determination on the employee's behalf, while with the overall goal of maintaining compliance. Quick question: I do not have access to a printer now. Is there a chance to fill out the form later, or do you have a fillable version? So the sign-in sheets do not need to be printed and wet signed. They can be completed digitally, whether you use Adobe to edit the PDF or if you have any sort of digital signature platform on your software, you can certainly use that and complete that form digitally. Another question in the chat: how far back does FMLA go? My husband died after a long battle with cancer in 2019. I'm so sorry to hear that. So he was working for a large corporation. He went on Medicare disability and has had his long-term disability given by the company lowered. Would he have qualified for FMLA? So would he have qualified for FMLA? So FMLA is provided up to 12 weeks of job protected leave within a 12-month period. So again, it does not provide any benefits to employees that are on FMLA. It's simply that their job is protected and they cannot be terminated by their employer while on a covered leave under FMLA. As far as how far back does the FMLA go, I'm not certain I understand what you mean by how far back it goes, but from the date of an individual's leave, they will have up to a 12-week maximum job protected leave, as long as that is within a 12-month period. Another question: how do FMLA and COBRA required health insurance interact? Elise, I might have to lean on you for this one.
So it's not really that they're going to be interacting. The FMLA is kind of first, and then the COBRA kind of comes in after once they're no longer eligible. But what I'll do is I'll put together something and shoot it over to you, Michael, like more specifics, so that we're not spending, all the FMLA time talking about COBRA, because they are kind of separate. So I'll put that together and I'll get it over to you then, okay?
Thanks, Elise. And thank you for the clarification on your question. Phyllis, was it around in 2019? So yes, FMLA was enacted in 1993. So FMLA was in place in 2019. And here we go to address your question, Michael Anderson, from earlier. So how is an immediate family member defined? It is a parent, spouse, or child. And the way that FMLA defines a parent is either the biological parent of an employee or an individual who stood in loco parentis to an employee, which basically means they acted as the parent, even if they didn't have that direct relationship or biological relationship with the employee, but on a day-to-day basis fulfilled the duties that a parent would. So that could even mean grandparents, foster parents, parents that had adopted them, which would be included in that definition of an immediate family member under FMLA. One other question. So during FMLA, does the company have to continue to pay the salary? Good question. The company is not required to continue to pay the employee's salary. Again, this is just job protection. So what FMLA states under federal regulation is that the employer cannot terminate the employee if they are out on leave due to a covered leave under FMLA. They will not be receiving any benefits or are required to continue to receive any sort of pay or salary from the employer during that time, but they simply cannot be terminated from their occupation while on a covered leave. Okay, so timing and types of leave. So tracking and recording of leaves. Employers have a few different options on how they track and record their leaves. Again, remember, it allows up to 12 weeks of job protection within a 12-month period, but how does the employer actually define that 12-month period? It can mean a calendar year from January 1st to December 31st, or any fixed 12 months, fiscal year, or the year starting on the employee's anniversary date. For example, maybe a group has a 6/1 renewal date on their medical and ancillary benefits. Well, maybe they'll use 6/1 to the end of May as their 12-month period to manage FMLA. They could also use 12 months rolling backward, which means if an employee submits a request for leave under FMLA, the employer would then review the 12 months prior to the date they requested that FMLA to see how much time they had used from that date, looking 12 months back in terms of that 12 weeks. And do they have any time remaining? Or they could use 12 months rolling forward, meaning from the first date an employee submits a request for leave under FMLA, that starts the clock. And then within the next 12 months, they have up to a total of 12 weeks of leave to use. Military caregiver leave is always going to be measured from the first day an employee takes the leave, so they do not have those different options there. And FMLA does not have to be a continuous 12 weeks of leave. It can be intermittent. Maybe an employee has a situation where they have to be visiting a provider once a week every Friday. Well, maybe that reason why they're visiting the provider is covered under FMLA, and each week they're going to be using one day up of that 12-week total leave. So over the course of 6 weeks, let's use this example. Over the course of 12 weeks' time, they would have used a total of 12 days of their FMLA job protected leave, not 12 weeks, because they were only out of work for one day each week. So if we think about an employer, HR manager, that is one, not only having to determine whether they should approve or deny somebody, right, but also keep track of all of their employees' leave. And they have to say, okay, John Smith is coming to request FMLA. Well, let me see, how much leave has he used so far? Is he still eligible for any leave? Well, he took 2 weeks last month, and he took another week last week. So, okay, he still has another 9 weeks of leave left. And maintaining all of that information for all employees at a company can be a lot to manage, which is one of the reasons why offering a solution to manage all FMLA and state leaves through a third-party vendor can take all of that off of the HR manager's plate, which is a huge advantage because it can really bog down employers. Another type of leave that or increment type that FMLA could provide leave for is a reduced schedule. So maybe an employee is only working 20 hours a week instead of their typical 40. Okay, next section, employer and employee responsibilities and rights under FMLA. So starting off with the employer requirements, employers are required to post a notice in the workplace approved by the Secretary of Labor, providing information on FMLA leave. Provide rights and obligations in employee handbooks or other written materials upon hire. Provide written notice of rights and obligations within 5 business days of receiving an employee's notice of the need for family medical leave. Determine if an absence qualifies. Notify an employee of his or her leave, or if his or her leave is designated FMLA. And of course, keep all forms and information about employees' leave and condition confidential and separate from other employee files. So originally, when a new hire comes on board to the company, the employer is responsible to make them aware of any FMLA coverage that they have. And then once they receive a request from an employee to go out on FMLA, the employer is responsible for providing them with all of the information that they need regarding next steps, how to qualify, eligibility, whether they're approved or denied, etc. Continuing the employer notification requirements. So the employer must provide a general notice, which is a summary of the FMLA law, rights and responsibilities notice, which outlines the employee's rights under FMLA, an eligibility notice, which says, yes, you are or are not eligible for FMLA, and a designation notice specific to the individual and whether the leave is qualified under FMLA that they had requested. Employers do not have to post hard copy notices in the workplace. They can post general notices online as long as they're posted to the employer's website or in a conspicuous location and accessible to all employees. The eligibility notice must include at least one reason why the employee is not eligible if they are denied under FMLA leave. They, of course, need to know why. If more than one leave has been requested in a 12-month period, but for different reasons, an eligibility notice will only be needed if there is a change in status. So if the employee requests leave the first time and they are denied, the employer has to provide them that eligibility notice stating they're denied. And then maybe a few months later, the employee submits another request for leave under FMLA that is also denied. The employer technically is not required to provide them with a second eligibility notice. Now, the employee's responsibility is to provide medical certification completed by a healthcare provider and returned to the employer within 15 days of their leave. If that medical certification is not provided by the employee within 15 days of the start of their leave, the employer does have the right to deny their leave, even if it would have been covered under FMLA. Not that they have to deny it, but they would have that option. Okay, responsibilities of the employee. So barring unusual circumstances, like if somebody is in a coma, an employee seeking a leave under FMLA must provide a 30-day advance notice of the need for family medical leave if it's foreseeable. For example, pregnancy. They must provide that medical certification within 15 calendar days and provide additional medical certification as their leave progresses as needed, second and third opinions if requested by the employer, and periodic reports regarding status and return to work. So typically when an employee is out on FMLA, employers will have a predetermined time period that they will follow up with employees, usually about 30 days, to check in on the status and potentially request additional certification or medical documentation if needed. And they might also require that employees follow a call-in procedure. Maybe, hey, while you're out on FMLA, and this might be something written in the employer's handbook, while you're out on FMLA, make sure to call and check in once every 2 weeks with us. Okay, so the employer gets a request for FMLA from an employee. What is then the employer's responsibility? Well, they have to figure out, okay, is the employee eligible? Do they meet the service requirements? Have they worked here for 12 months? Do they meet that 1,250 hours worked within the last 12 months? Has the employee exhausted the entitlement? So has this employee already utilized 12 weeks of FMLA within the 12-month period, or do they still have FMLA available? Is their specific leave eligible? And does it meet qualifying requirements? So as you can see, this for each leave request that an employer gets, there's a lot that they have to go through. And again, all of this comes down to maintaining compliance under this federal regulation that can be a lot of a burden on these HR managers. The employer must send the eligibility notice and rights and responsibilities notice within 5 days of the employee's initial request. That rights and responsibility notice must include that the leave may not be counted against the employee's annual entitlement, requirements to certify or support the need for leave, requirements to substitute paid leave, and the right to take unpaid leave if the leave cannot be substituted. So the employer has the right to medically recertify the leave every 30 days. They can require annual certification if the condition lasts beyond a single year. So if that employee exhausts the full 12 weeks of FMLA in the first 12 months, and that employer still chooses to maintain that employee and does not terminate them, and over 12 months, if that employee is still out, they will have a new 12-week period in that new year under job protected leave, but the employer does have the right to request certification of the condition at that time. And again, those medical certification requests by the employer should be made within 5 business days of the employee notice or 5 days after the leave commences for an unseen leave. So there's a lot of, to boil it down, rules, regulations, timelines that both the employer and employee need to be aware of in order to properly adjudicate an FMLA leave. So when the employer receives a request for leave, they can request authentication from the healthcare provider regarding the medical documentation that the employee provides, just to authenticate and verify with the provider that they actually did complete that and that it is accurate and legit. And they can contact the provider to understand any questions or the meaning of any information on that report as well. But the key point here is that, of course, the medical information is protected by HIPAA. So the employer cannot require or request any additional information outside of what was already provided on that medical certification form. Okay, so moving into state leave laws. Again, FMLA is federally regulated job protected leave. It is unpaid job protected leave. And that is across the entire country because it is federally regulated. But there are some states, currently 14 states, that provide their own statutory leave laws in addition to the FMLA job protection. Now, some of these states might even have multiple different types of leave laws, and they typically do provide benefits. So it's typically going to be a paid leave that the state provides. Some of them might do for just medical leave, some of them might do just family leave, and some of them might provide both family and medical leave paid benefits. Currently, the 14 states are California, Colorado, Connecticut, DC, Hawaii, Maine, Maryland, Minnesota, New Hampshire, New Jersey, New York, Oregon, Rhode Island, and Washington. Delaware and Maryland will go into effect January 1st of 2025. They are going through legislation now, and things are constantly changing, so nothing is fully set in stone yet regarding the ins and outs of how their state leave laws will work. But Delaware and Maryland are nearby to Pennsylvania, so that is something that we all might start to see and is important to become up to speed with. And Vermont is looking to add state leave in July of 2025. So again, the types of leaves that states can offer or provide is either family medical leave or just family or medical leave, pregnancy disability, baby bonding, bone marrow donation, volunteer firefighter, school activities leave law, domestic violence, and kin care. All right, common errors and consequences. So again, FMLA and the compliance of it is fertile feeding grounds for attorneys, I'll say. Like we saw in the example on the first slide, the payouts that employers are responsible for can be extremely substantial. The government does not take this law lightly, and it is extremely important for employers to maintain that compliance. So the most common ways where employers might struggle with administering FMLA is confusing regulations from state to state, how they define serious health conditions, tracking the leaves and entitlement. Again, leaves don't have to be 12 weeks continuous. They can be intermittent throughout a 12-month period. So tracking all of that can be a lot of work. All of the varying state regulations in multiple locations. Maybe we have a 200 life or a 200 employee group, and they might have employees in 8 different states. Well, maybe 4 of those 8 states also have a state leave on top of FMLA. Keeping track of all that, managing it is a lot for HR managers to do. They might have inconsistency in administration and staff expertise, managing unforeseeable leaves, and addressing state and budget constraints. So the common errors that employers will make continued is failure to notify employees of their rights, failure to notify that leave will be counted towards the 12-week entitlement. So maybe they approve somebody's request for FMLA and they do not inform the employee that they're only protected for up to 12 weeks, and the employee fails to recognize that because their employer didn't tell them. Or an employer might count FMLA leave against the absentee policy for disciplinary purposes. That is, of course, not allowed. So if an employer has a rule in place, an absentee policy rather, where employees cannot miss more than 10 days of work in a 6-month period. Well, if an employee is out on job protected FMLA leave and they are out of work for at least 10 days, they still have that full 12 weeks of job protection. And if the employer says, oh, you've been out of work for 10 days, you violated our absentee policy, we're going to terminate you, they're going to end up in court because that employee was covered and they are not able to be terminated while covered under FMLA. Or taking, of course, any disciplinary action against employees for using FMLA. Failure to grant leave to provide care for a seriously ill parent or child. So this is another common mistake that employers might make, is they think that FMLA only covers the employee's own medical condition and fails to recognize that family leave piece. And if an employee has to care for an ill parent or child, that most likely will be covered under FMLA as well. If they terminate employee during or at the conclusion of leave, misunderstanding serious health conditions, failure to request a certification in writing and not giving 15 days to obtain it, or failure to handle questions about medical certifications according to FMLA guidelines. So one more time, just going over an explanation of how to maintain compliance. So non-compliance, an employer denies a request for FMLA leave that should have been approved, well, now they're facing the potential of Department of Labor fines, employee lawsuits, individual manager liability, and really just the concern of breaking the law and having to pay a lot of money for that. And then there's overcompliance, where employers are just green stamping, approving almost any request that comes their way for FMLA, which employers should not do, because that's going to result in reduced productivity, time theft, employees take advantage of it, poor employee morale, and setting precedent where other employees will try to do the same thing, essentially take leave when they don't need to, because their employer is not managing FMLA correctly. All right, so we're coming up towards the end of the presentation here, just a couple more slides left. This slide is discussing whether a group handles absence management, FMLA and state leaves in-house, or if they work with a third-party vendor to manage that for them. So, of course, if the HR manager or company manages FMLA and state leaves in-house, then all of the burden of remaining compliance and all of that tracking information is on them. Well, there are different options of third-party vendors to manage that leave for groups. Now, a lot of them will have requirements, typically 300 or more, or maybe 500 or more employees in order to manage FMLA and other leaves for the company. Mutual of Omaha does offer an absence management program for groups down to 50 employees in size. If we remember, groups are eligible for FMLA and required to provide it if they have 50 or more employees within a 75-mile radius. So for those groups, we do have a solution to be able to manage FMLA and other leaves for those employers. And another advantage of having a third-party vendor handle that for employers is that it helps streamline an integrated process between FMLA and any state leaves, as well as their short-term disability if they offer short-term disability. It makes it a really easy process for employees to do more of a one-call does it all, where they submit their request for FMLA to this third-party vendor, which then reviews it for approval or denial, and then also simultaneously submits their claim to the insurance carrier to begin the short-term disability claim for them. So now the employee doesn't have to file their short-term disability claim and submit their request for FMLA separately. That has now become an integrated process. Yes, okay. So on the next slide here, this just provides some additional information around the absence management program that Mutual of Omaha provides, which is through FMLA Source, run by the parent company ComPsych. It's located in Chicago, and it offers both FMLA and ADA management services for groups, again, with 50 or more employees. It is also offered by Mutual of Omaha through ComPsych without any implementation fees. So some of these vendors might charge a few $1,000s of an original implementation fee for this type of service. Mutual of Omaha does not. And also our PEPM cost for the absence management is typically around $2.50 PEPM versus a lot of other vendors out there that might charge $3 or $4 PEPM. And depending on the situation and the group size, the lines of coverage, etc., there is also potential for us to help subsidize the cost of that absence management service. So to sort of recap the importance of FMLA and state leave management for employers and the impact that outsourcing that could have is, as we saw throughout the presentation, which we are at the end here, there's a lot for HR managers to keep track of. So having the ability to outsource that will take all of that off of their plate, and the situation would look more like this. Employee submits a request for leave under FMLA to the third-party vendor that's handling it. Now the employer does not have to determine whether or not it's approved or denied. That is now in the vendor's hands to determine, which ensures compliance. They're not going to be approving requests that should be denied or denying requests that should be approved. There's a full legal team of support to help in any type of lawsuits that might arise. And then they're also going to keep track of all leaves for all employees at the group, and also determine, does this employee also qualify for any sort of state leaves as well as FMLA? If so, we will actually provide them with a full packet outlining everything that that employee would be eligible for and what those next steps are, which the employer now no longer has to do. So it's a great solution. Again, another arrow for your quiver to be able to discuss and provide. But that, again, is the end of the presentation. So if anybody has any questions for me, just let me know. Elise, I see you popped on. So
I'm here.
Hey.
I think it's me that's having kickback. There is one more question in there. I can't remember if you answered it or not, so I'm sorry if you did. During FMLA, does the company have to continue to pay the salary?
I did address this one. Yep. So,
Okay.
okay, no worries. The company
that was the only question that I couldn't remember if you had answered or not. So the rest have been taken care of.
Excellent.
Yeah. Just as a reminder, download the form. It's 11 a.m. to 1 p.m. It doesn't have to be wet signature. You can fill it out electronically. You can shoot it back to me. My email's in the chat. And I will get it over to Rocco to have him do his thing with it.
Thank you, Elise, and thanks all for joining. Hope everybody enjoys the rest of their day and has a good weekend.
Thank you, Rocco.
Thank you. Take care, all.